I'm declaring a mistrial in this case.
She's a whack job.
And yesterday, during the entirety of your questioning by Mr. Lowry, not once did you mention that this video is actually completely inverted.
I did not know.
Karen Reed's attorneys expressed frustration over the fact that the Commonwealth wants to totally ignore jurors who say they were unanimous in acquitting Karen Reed on second-degree murder.
And just weeks after declaring a mistrial, the attorneys are at each other's necks with new filings.
We're beginning to see disillusionment in the state of Massachusetts over the first trial. What steps are going to be taken to resolve this case?
Karen Reed's attorneys are having nothing of the Commonwealth saying, oh, just ignore those jurors who say they were unanimous in acquitting Karen Reed of second-degree murder. Hi, I'm attorney Andrew Myers. On this edition of About the Law, we have Southern California attorney Yoli Medina. Hey, Yoli.
Hi there. How are you?
And we're great. And intern Red is also with us. How are you, Red?
I'm good. Thank you.
So the news in the case at this point, and it's a very volatile thing, and it's ongoing, and we have no idea what's going to be happening in the Karen Reed case going forward, is that, of course, a motion was filed to dismiss 2 charges, including second-degree murder. Then the Commonwealth filed their brief saying, you know what, the case law was wrong, there's technicalities. And the reply brief comes out, and Yoli, that's what we're talking about today. Were you surprised that a reply brief was even filed?
No, not at all. I mean, that's typical. I would expect that.
Yeah, so I don't know how it works in California, but in Massachusetts, where I've practiced for many years, that's what happens. You file a motion, and the opposing counsel is allowed to file their opposition, and then a reply brief is filed. Is that how it's done out there?
Yes, that's how it's done. I'm just wondering about a hearing, whether the judge is going to set it for a hearing.
Why don't we actually take a look at the motion itself? And actually, it's a reply brief. Why don't we take a look at it? It was just filed before we're doing this episode. But there it is, Karen Reed's reply to the Commonwealth's opposition to her motion to dismiss. And what Karen Reed's attorneys are saying is that the Commonwealth's opposition is perhaps most notable for what it does not dispute, that according to information from 4 deliberating jurors, the jury had reached a unanimous decision that Ms. Reed is not guilty on 2 of the 3 charges pending against her, namely counts 1 and 3. The Commonwealth's insistence that Ms. Reed must nonetheless be forced to run the gauntlet once more is based on several clear fallacies. So there's nothing really surprising in that, is there, Yoli?
Well, no. The defense has provided evidence by way of affidavits, about the juror, at least one juror reaching out to Mr. Jackson, and then a couple of other intermediaries reached out to Yannetti. So that's evidence, the affidavits that were filed, and the prosecution doesn't submit any evidence to refute that. In other words, a declaration from the prosecutor or a juror saying that that's not true. We didn't reach a verdict on the manslaughter count. Nothing like that was filed. So there was no evidence to contradict what the affidavit said in the defense's motion to dismiss.
Yeah, that's a really good point. Faced with opposing counsel, when you have had a motion filed with supporting affidavits, you have a couple of options. And one is to to provide evidence that contradicts what's been stated in the initial motion. And that was not done here. What they're doing is what the Commonwealth was saying was that, we'll make legal arguments. But that wasn't good enough for Reed's attorneys. They say for several reasons. First, while the defense was given an opportunity to be heard on other issues arising during jury deliberations, for example, the appropriateness of a Tui Rodriguez instruction, the defense was provided no opportunity to be heard regarding the declaration of a mistrial. Rather, upon receiving the final jury note, the court sua sponte, and what that means is on its own, declared a mistrial with no warning to or solicitation of objections from the parties. Secondly, the jury's note did not explicitly indicate an impasse on all charges. To the contrary, it was readily susceptible to the interpretation proven correct based on information received post-trial from deliberating jurors that the deadlock applied only to the multiple offenses included with the count 2 and not to counts 1 and 3. Third, and finally, the defense respectfully submits that neither the Commonwealth nor the court carefully considered alternatives before declaring a mistrial. The record reflects no discussion of any such alternatives, including, importantly, inquiry regarding whether the jury had reached an impasse on all as contrasted to just some of the counts. Yoli, my impression is that basically what the Reed attorneys are saying, although persuasive, is saying, if you read between the line, the judge had other options that she could have and should have followed, and she didn't. So in my experience, getting a court to acknowledge that there was some error is not something that often is successful. Am I off base on that?
No, you're on base. It would be, I mean, she would have to basically agree and that she did not explore other alternatives, including allowing the defense to have a say or the prosecution to have a say, or to even poll the jurors as to what counts they were deadlocked on. So she is not likely to criticize her own self by agreeing with that.
Yeah, it's a difficult thing. Red, hey, I'm interested. You're our summer intern, and I said before that you came to us, saying, I don't really know if I want to be an attorney. I don't really know if I want to get in the legal profession, but I'll spend a summer with you to figure it out. Is all this confusion? Is all this back and forth? Is this turning you off to the whole idea of entering the legal world?
No. I mean, there's a lot to fix out there, and that's kind of my thing. I like fixing stuff. So I'm not really afraid of it. I mean, it's unfortunate that it's happening. But I wouldn't say that it scares me away from the profession at all.
Okay. Do you find it like you seem to be following it really closely, and I'm really impressed with that. But do you find that some of it is just a lot of verbiage that doesn't make sense to the general public?
Yeah. Yeah.
We didn't even discuss this before we hit the play button. So that's how you feel. You feel that it is confusing to a lot of people.
Yeah, it's confusing to me. I mean,
Yeah.
All right. Well, stop us. Yoli and I, we've both been practicing law for many years. We've never practiced together. We don't know each other that well. We've gotten to know each other through doing these episodes. But break in and ask us questions. Here, I've seen other people just read this, and I don't know. I just find that boring. I really do.
Yeah,
So I've highlighted stuff that I thought was important. Even if first trial is not, and this is Karen Reed's defense attorneys making their argument as to why the court should dismiss 2 counts, including the second-degree murder. Even if the first trial is not completed, a second prosecution may be grossly unfair. It increases the financial and emotional burden on the accused, prolongs the period in which she is stigmatized by an accusation of wrongdoing, and may even enhance the risk of an innocent defendant may be convicted. Consequently, as a general rule, the prosecutor is entitled to one and only one opportunity to require an accused to stand trial. This is really basic stuff, isn't it, Yoli?
Yeah, it is. And, the issue is, I think this is a case of first impression. I think it is where it's not clear, and you have the jury speaking out after the verdict or after the mistrial where they couldn't agree and saying things that it wasn't clear, or they were confused by the jury instructions, or they all agreed that she was not guilty of manslaughter. So I don't know if this has ever happened in Massachusetts. I can't think of a time that it's happened in California, but with that caveat, it is pretty basic stuff. But the issue here is not basic. It's something of a first impression.
Yeah, no, you're right. There's been nothing like this exactly in Massachusetts, because I have been watching and reading a lot of the legal quote unquote experts who've been practicing law. Well, I've been practicing law in Massachusetts for 35 years, and others have been practicing even longer than that. And I've seen and heard and watched them say the same, what you just said, Yoli. There's no case on point. And so that's why they're making these arguments around the edges. Well, there's Rule 27, which we quoted last time, which says the judge could have asked the jury for whether or not they were deadlocked on all three counts, but it's not really clear. And so I'm thinking that this case is going to make not only law, but some changes in the rules, because you're right. This exact circumstance having happened before, just it's not there. So whether the jury acquitted Miss Reed or alternatively was merely not deadlocked on the relevant counts, the Constitution compels the same result: dismissal. Given the unambiguous post-trial evidence, it would simply be wrong to require the defendant to obtain two acquittals from two different juries for the same crime. And that would absolutely, first of all, the concept is true. You can't even argue with that concept. But in a case like this, where the jury went home for the 4th of July holiday on the 1st of July and just said we're deadlocked on the counts, plural. The issue is, what did deadlocked on the counts, plural, what did that mean? And did that merit additional inquiry by the judge?
I think it did, because now that I'm reading, when I read the reply, it seems that the note said we cannot come to an agreement on the, well, I don't know the exact verbiage, but on the charges.
Yeah.
And it didn't say which charges.
No.
It didn't. If it would have said we can't come to an agreement on all of the charges, that might be different. But it just said charges. So now I'm thinking that is ambiguous. And then you have evidence that at least some of the jurors said that the jury found her not guilty on manslaughter. So I think at this point, it probably requires the judge to let the attorneys inquire of the jury, or the judge inquire of the jury. I don't know.
Yeah, far be it from me to question people above my pay scale and above my level in the profession. So far be it from me to question, but it does raise an issue as to, when you have a trial such as the Reed trial, which had 74 witnesses and went on for 30 trial days, and which had over 600 exhibits. The trial started April 16th. And the final and fourth jury note came out on July 1st. So if I'm not mistaken, I don't think there was snow on the ground, but it was still pretty cold in April. And now we're in the middle of a heat wave. July 1st was a hot day leading up to a hot 4th of July. The point being that an awful lot of work, effort, time, expertise. Yoli, preparing for trial is stressful. I don't care if it's a little fender bender or a major case like this. It's stressful. So for all of that to have happened, and for there not to be more questioning, and I'm not saying to parse. I'm not saying to do anything invasive, but just ask the jury, hey, let's go through this 1, 2, and 3. So. Yeah. I don't know.
And it's Monday morning quarterbacking, or whatever they say about that. And it's something that it happens so fast. And I think if the judge had been a little more thoughtful, which I don't know what she was thinking at that time. She was probably frustrated herself. I don't know. It's just one of these first impression things that comes before the court.
Well, I'm not going to say it, but others have said that, it was July 1st, a Monday. The 4th of July was a Thursday, and people's minds turned to a holiday. geez, do I have enough burgers? Do I have gas for the grill? Who's going to bring the potato salad? Does Aunt Mary have a ride? She can't drive. So, these are the sorts of thoughts that are on people's minds. And again, I really don't want to question anybody who's above my level on the pecking order in the legal area. But at the same time, there was an opportunity that was missed. I guess I'll just say it that way. So one of the important points I thought that the defense attorneys made was that the Commonwealth is really, and we've already established that there's no precedent. So they're working this case around the edges. And one of those edges is kind of the formalistic question as to, just because the jury did agree unanimously, does that rise to the level of a verdict? And here is how Reed's attorneys respond to that. The Commonwealth's leading argument is rooted in pure formalism, that no verdict was entered on the record in court. But precisely this formalistic mode of analysis has been consistently rejected by the United States Supreme Court and Supreme Judicial Court in a string of precedents spanning more than 100 years. So, what they're saying here is that, there is precedent, not for this exact situation, but for the fact that, hey, we have to look beyond just what happened on the jury verdict form and what was reported to the judge. We have to look beyond all that. And they cited some federal and Massachusetts law to back them up.
Yeah, that it's like the prosecution. Well, the defense is arguing that the prosecution is putting form over substance. That because there was no jury verdict on paper recorded, or anything like that, that automatically means there was a verdict, or there was no verdict. They're trying to say that it's form over substance, and so yeah. And then this lack of manifest necessity. I'm glad you're bringing that up. Go ahead, talk about that.
The lack of manifest necessity to support a mistrial provides a second independent basis for dismissal. While there is no doubt that a jury deadlock may constitute manifest necessity, the Commonwealth unsurprisingly cites no support for its contention that a deadlock on some, but not all, separately indicted charges supports declaration of a mistrial with respect to all counts. So, Yoli, getting back to the point that you made at the very beginning of our conversation here, you were saying, isn't it interesting that Reed's attorneys have affidavits and facts, and that the state did not have affidavits or facts. They just had their argument. And what Yannetti and Reed are saying here is, look, they don't even have support for the contention. Several times in this brief, the defense attorneys say they're making arguments that they have no legal support for. So it's an interesting argument they've made. Given that there was no deadlock on two of the three counts, it follows that there was no manifest destiny to dismiss the jury without receiving its verdict on those two charges. The defense does not suggest that the court was required to give the jury new options for a verdict, only that it should have asked straightforward questions of which the separate indictments the professed deadlock related to. In essence, the Commonwealth's contrary position asks this court to close its eyes to the possible, or even as here very likely, existence of partial unanimous verdicts on some, but not all, separately charged counts to avoid the risks of juror coercion. So, and then they get into one of the cases that was cited, Commonwealth versus Roth and Bluford and Juvenile, and they go into a pretty deep legal argument. But I put a little red arrow here because this was an important point. A lot of times, some of the important stuff is hidden in parentheses.
Yeah.
Where a complaint or indictment in multiple counts charges multiple crimes, a general verdict could be returned as to one of the counts, despite deadlock on the other counts. And this is in the notes of Rule 27, which we've talked about in two previous episodes, so I don't feel the need to bring it up. But the reporter's notes provided that the court may declare a mistrial in cases where the jury is unable to reach a verdict. However, it must first receive and record the verdicts which the jury can agree on. So this goes beyond our, you and I had both said, well, geez, maybe the judge could have asked more questions. Maybe she didn't have to, maybe, under the pressure of time. This note to the criminal rule that's applicable here indicates that it was her duty, that it was her job, that the judge did have legal precedent when given a note saying that there was a deadlock, that the court
Must. It says
must.
it must. Mhm.
The court says it must. The court says it must. And I don't know if I can do a little highlight here, but there it is. There's the language right there. And can I put a little red on it? I can. There we go. No.
She did, yeah, and the thing is, she didn't even ask which counts they were hung up on.
No, she didn't.
I know. Yeah.
No, she didn't. So when this case goes up on appeal, and yeah, I said it. When this case goes up on appeal, there's the language in it's only a reporter's note, but it's right there in the rule books in Massachusetts under Criminal Rule 27. And, that's mandatory language.
Yeah. Yeah. Even though the text of the rule is a little ambiguous, but it sort of clarifies it in that note.
Yeah, the rule would have allowed for it. The rule would have made a suggestion. The rule would have said, here's good practice. And I always liked that when I was first learning how to practice law. I mean, there's nothing like actually being thrown into a trial and doing it. But something that I always thought was interesting when I was first practicing law and I went to the continuing legal education seminars, they would say, it's always best practice to do this, or it's always best practice to do that. And I would go, yeah, right. Well, here's an example where, yeah, it is right. That's a best practice. And, so they go on to say the inflexible prohibition on jury inquiry regarding partial verdicts advocated by the Commonwealth would inevitably undermine the defendant's important and constitutionally protected interest in being able once and for all to conclude their confrontations with society through the verdict of a tribunal they might believe to be favorably disposed to their fate. So, it's not just an issue of, Rule 27 says I could have, should have, would have, but, it's not that clear. We're not talking about, geez, should I get the lean hamburger or the fatty hamburger? We're talking about a person's constitutional rights and whether they're going to spend the rest of their life in jail or whether they get a second trial, another 74 witness trial. It holds a lot of gravitas trying to figure out, what that rule would have had them do.
Yeah.
So,
and the evidence was, at least the evidence that I saw, which wasn't the whole trial, but it just seemed so weak and biased to me. And they overkilled it. They over prosecuted it with so many witnesses. And at the end of the day, it ends up with a mistrial. So it's like, really, you want to retry this again?
Yeah, the comments that we're getting go that way. And we had that jury consultant on several episodes ago, and I know you were here for that, and she said the same thing, that the jury was just way overwhelmed with a ton of evidence, and if and when the trial is held again, they might want to really think about honing it all down. And this goes right to the point we were talking about before, that the Commonwealth, really didn't cite a lot of law. The Commonwealth's attempt to shift blame to the defense overlooks the black letter rule that the prosecution alone bears the heavy burden of establishing manifest necessity for mistrial. It's indisputable that the court provided no opportunity for the defense counsel to be heard regarding the declaration of a mistrial, as opposed to the appropriateness of a Tui-Rodriguez instruction. In short, mere silence absent an opportunity to object does not amount to consent. And they cite a bunch of different cases. And as I always say, the footnotes and the parentheses often hold the really important stuff. And here's a 1996 case, which really isn't that old, holding that where the trial judge did not ask defense counsel to comment on the possible declaration of a mistrial, the lack of an objection from defense counsel cannot be construed as consent to such action. So
there you go. There's law.
yeah, Yoli, I found some of my commenters saying, "Oh, well, they didn't object. You know, they had plenty of time. They could have objected." And then when the court, asked them to get out their schedule books and decide when they could come back to schedule the trial date, they didn't object. Doesn't matter. Doesn't matter. Here's a 1996 decision, which I don't know how it is in California, Yoli, but here in my jurisdictions, that's a recent case.
Yeah, well, I mean, as long as it's good law and it hasn't been overturned on that issue, or, it's good law, and I'm assuming it's good law, so that's right on point.
Yeah, holding that where the trial judge did not ask defense counsel to comment on the possible declaration of a mistrial, the lack of an objection from defense counsel cannot be construed as consent to such action.
Now, the question I had, though, is that going to be an argument for appeal, or can the judge consider that argument on a motion to dismiss? That's a question.
Well, it goes back to what we were discussing before. Is a judge really going to say, "Oh yeah, I screwed up. I'm sorry. Let's," I mean, it's. I think.
No. I mean, she might say, "I should have given you all an opportunity," in the haste of the situation. I didn't do it.
You know what I think? And I kind of alluded to it before. I think this case is headed for an interlocutory appeal. That's what I think.
There you go. Mm-hmm. Yeah.
I think I said this in our last episode on this case that what really needs to be done, or at least what Karen Reed's attorneys are indicating needs to be done, is that the jurors need to be polled. The jurors need to be brought back and polled and asked, is this true? Is this true that it was unanimous on counts 1 and 3? And if it's true, what's the remedy?
Yeah.
In this reply brief that we're talking about now says the remedy is dismiss. I can't see this going to a trial date. I can only see something being done with respect to addressing this. Only a couple more points in this memo. Oh, again, the Commonwealth cites no support for its suggestion that an attorney who receives a call post-trial stating that the jury had acquitted his or her client must simply hang up the phone and not act upon that information. What they're saying here is that Adam Lally in the Commonwealth's brief had kind of said, you can't talk to jurors. That's improper. You can't talk to the jurors. But what Reed's attorneys are saying is that the jury's agreement that Ms. Reed is not guilty on counts 1 and 3 reflects the results of the deliberative process, not the contents of jury deliberations or the thought processes of jurors. So as you pointed out in our last episode, you said, well, it wasn't the attorneys reaching out to the jurors. It was the jurors reaching out to the attorneys. So this is the icing on that cake, that the attorneys didn't ask them, well, geez, what were your thought processes? Geez, what witnesses did you find credible? What went into your decision? Because that would have been improper.
Right. And that wasn't in the affidavits either. So the evidence before the court doesn't have anything about that. And what's before the court is before the court. And as attorneys, as officers of the court, the defense counsel, they have an obligation to be truthful. So you have to assume that their affidavits are truthful, that they're not committing a fraud on the court by being untruthful. You have to assume that they're truthful. And so with that said, it seems like the defense provided evidence, which is information that they received from jurors. One was firsthand, and the other two were secondhand. And the court has that before it now.
Yeah, I agree. And I really, I've never really engaged in going around talking to the jurors, but, I don't think there was anything improper. And again, the Commonwealth's brief just made these allegations without citing anything. How about this? One of the legal precedents that's cited here by Reed's attorneys is 2016. In terms of the law, the ink is still wet on that decision. Although we don't ink anything anymore. I know. I'm showing my age.
Yeah.
At the same time that the Commonwealth criticizes the defense for purportedly infringing upon the jury's deliberative process, it also paradoxically, I love this language, it also paradoxically faults the defense for reliance on hearsay. But the affidavit by counsel in Commonwealth versus McCallop attesting to alleged jury bias was no less hearsay, and the Supreme Judicial Court squarely held that it entitled the defendant to further inquiry on the subject. The defense submits that the same result is warranted here.
And there you go. You have law. You have law that supports that they can submit hearsay evidence.
Yeah.
Well, you know, the burden is whether or not there's enough to inquire of the jury, I guess. And I think that the defense has met their burden, I think, with the affidavits. So that's just what I think.
I hear a little sound in the background. Is there a cricket?
No.
Is there a cricket?
Not that I'm here.
Red, what do you think of all this?
I think that this case really just highlights that what the courts don't do is just as important as like the controversial things that they do. Like this is, you know, I'm seeing a lot of negligent behavior here. This is somebody's life, you know.
That's a good point. Yeah.
Yeah, I mean, if you're a Karen, you know, by the way, the big headline in the local newspapers is that Karen Reed has put her house on the market. And I can't say I blame her. I mean, you know, with everything that's going on, with all the publicity, with the last, you know, the entire spring from April to 1st of July of 2024 was, you know, this was top of all the news. I can't say I blame her. You know, she doesn't want to live in Mansfield anymore. She wants to move. So, you know, that's certainly her right. That's her business. That's, you know, but I certainly, you know, I can certainly understand. I mean, look at the throng of reporters in that last picture. I mean, she certainly, you know, shouldn't have to deal with that. So in any event, so I guess, Yoli, what do you think is next? I mean, the court, I had laid out the options in our last episode, and one option was doing nothing. And you pointed out correctly, probably, that that's not a good option.
No, I think the judge has to well, I mean, if there's a motion before the court, a motion to dismiss, I don't know what would allow the court to ignore that. It has to be heard, I think.
Well, they could just deny it. I mean,
no, they can deny it, but it has to be heard. It has to be heard in court. They need a chance to argue, and then she can deny it if she wants. But I think they have to have an opportunity to be heard, is because there's a motion, something pending before the court, and if the court doesn't address it, it's just there. It's open.
So I'm trying to figure out. I always, you know, in retrospect, I'm always amazed by alternatives. So one extreme is, okay, let's call all the jurors back and do a very brief kind of an inquiry like they did in the Murdoch case. And yes, commenters, I know that that was a totally different issue, but it's an on-point kind of a thing, bringing the jurors back. So that's one option, bringing the jurors back. And if true that they were unanimous, dismissing 2 counts and holding a retrial only on the second count, if at all. And the other extreme, I guess, is to just simply deny it and schedule a new trial. But I always wonder, you know, what alternatives could there possibly be in between those two extremes? And I'm racking my brains right now. And courts often, you know, having, you know, roundtables with a bunch of different judges, they can come up with some other option. It's just that I can't think of what it would be. Can you?
Well, you mentioned an interlocutory appeal, and I don't know if Red knows what that is, but that is an appeal that happens when the action is pending. So theoretically, the action, because a motion to dismiss was filed on the charges that were brought before, theoretically the case is still pending. So if the judge denies this motion, let's say the judge hears the motion and denies it, then if the defense appeals, wouldn't that be an interlocutory appeal?
Of course, yeah. That's what an interlocutory is, just a fancy word in between two different courts, from one court to the other. From the in Massachusetts, it would be from the Superior Court to the Appeals Court.
Yeah.
And then ultimately to the Supreme Judicial Court. But initially in Massachusetts, we go to the Appeals Court. If you're in the district court in Massachusetts, by the way, there's the state district court, there's a district court level appellate panel, which I've gone to. If you get a result you don't like in the district court, you can go to the district court appellate court before you go up further. But Superior Court, I should say, you go up to the Appeals Court. In Pemberton Square, which we have a picture of it in the background there. It's in that same building over to the right. But anyhow,
so normally what would have to happen is the case would have to be completed, a final judgment or final verdict to be completed before you can file an appeal.
Right.
In California, we have the final judgment rule in civil law, and it has to be completed before you appeal. But an interlocutory appeal is when it's in the middle of the case has not been completed yet. And so
the only other option that I can think of, and this would be Adam Lally's dream, bring the jurors back, question them one by one, and one of them says, "Oh no, it wasn't unanimous. These other four people that have talked to Attorney Jackson and Attorney Eddie, no, they were wrong."
But I would think anyway, if the jurors heard that some of the jurors reached out to defense counsel, if that wasn't true, I would think some other jurors would reach out to the prosecution and say that's not true. Because if it wasn't true, then some of the jurors who are hearing this might think, if that's not true, I'm going to tell the prosecution. But that didn't happen.
No, that hasn't happened. I mean, I don't know how I'd feel if I was in their shoes. I think if I had been one of the holdouts, I think, I would have come forward. Let me ask Red another question. A lot of people don't want to do jury duty to begin with, but if you got a jury duty form in the mail today, having followed this case as we've brought you into it, what would your feelings be if you got a form in the mail today to serve on the jury?
Anxiety. I don't know how they're punishing these jury members for not saying what they want them to say. I don't trust the Canton Police Department. I don't trust them. And how are they treating the members of the jury? That's definitely something you should consider.
Yeah, my thought is just that, oh my gosh, that it would take this long. I mean, if you're retired, fine. If you're retired, and I have some good friends that are retired, and we've had this conversation. Oh, I'd love to be on a jury, and that's great. That's great because they're retired and they're still mentally sharp and they still, read the news and they're up on things. But for anybody that has a job, especially younger people that have kids and have a life,
it's a burden.
It would be an incredible burden to be on a jury that goes on for this long, 2.5 months. And then after that to be called back. It's just, so I don't know.
Yeah. I mean, your attention span, what happens in between the beginning and the end, sometimes you lose what happened in between. And that's why some attorneys put the weak evidence in the middle of their case so that it gets forgotten. But in this particular case, it seemed like every witness that I saw portions of their testimony, it was just bad for the prosecution. It was just bad.
Yeah, well, a trial that goes on that long, I was towards the end, I couldn't remember the earlier witnesses, and I was having to go back down to my notes, and I'll admit, I'm not the best note taker. I'm just not the best note taker. So I had to go down to, I'd also been saving some newspaper articles. Well, if you're in a jury, that's a no-no. You're not allowed to
look at stuff, yeah.
Let me ask you a question. When jurors are told, don't Google anything, don't read anything, don't talk to anyone, do you think they do that?
I think most of them do. But there's always those that can't help themselves. I think if it's a very boring trial,
Yeah.
then probably all of them won't. They want to get the hell out of the courtroom. They don't want to, if it's a boring trial. But if it's an interesting trial or a high-profile trial, then I believe some of the jurors probably do snoop around. But unless you can't really do anything about it.
Red, I'm going to ask you one more question. I'm going to put you on the spot one more time. And please don't be insulted by this. Well, you might be anyhow, but people of your generation pretty much live on their phones. Am I right?
I guess, yeah.
You're on your phone or your tablets or whatever pretty much all the time. Am I right?
Yeah.
Okay. So now you are put on the jury and you're told, and you're there in the jury for 6 weeks and you're told, do not read the news, do not talk to anybody, do not Google anything. Do people take that seriously, or do people kind of go, oh, wait a minute?
Well, I don't think it's do not Google anything.
Well, do not Google anything about the case. Do not Google anything about the case. Do you think that people would honor that, or do you think they would sneak around and kind of Google stuff?
I don't know. I guess it just depends on the person.
Okay.
Everybody's different,
Okay, I didn't mean to put you on the spot. That was unfair of me. So, any closing thoughts, guys, before we head out?
No, I'm just curious to see what happens. I mean, I want to,
Yeah.
What is the judge going to do? Because what if she does ignore it, like you say, just ignores this?
I don't know.
I think there'll be an interlocutory appeal for sure.
Yeah. Okay, people, be kind to each other, whether you're in the grocery store or in the gas station. Please be kind to people. We don't know what the other person is going through in the end. We don't know what their mindset might be. So please be kind, be respectful. Please give us all the comments you want to give us. But in the end, we hope that you won't personalize it. And in any event, have a great day. You have been watching About the Law, a production of the law offices of Andrew D. Myers in Methuen in the Merrimack Valley of Massachusetts and in Derry, just outside of Manchester, New Hampshire. Remember to click the like and subscribe buttons down below. And if you enjoyed this video, be sure to share it with your friends and others. If you'd like to talk to me about an injury case, a car accident, a slip and fall, a serious bodily injury case, or some other case, please feel free to contact me. I'd love to talk to you. You can contact us through my website at attorney-myers.com. We have a contact us block, or you can call on one of the telephone numbers we've given there, or you can email me at andrew@attorney-myers.com. The foregoing is offered for informational purposes only. It is not intended as and does not constitute legal advice. Laws vary widely from state to state. You should rely only on the advice given to you during a personal consultation by a local attorney thoroughly familiar with state laws and the area of practice in which your concern lies. This podcast must be and hereby is labeled advertisement in some jurisdictions. And
Okay.
that's that.
And that's that.
All right.
I'm declaring a mistrial in this case.
She's a whack job.
And yesterday, during the entirety of your questioning by Mr. Lau, not once did you mention that this video is actually completely inverted.
I did not know.
We're beginning to see disillusionment in the state of Massachusetts over the first trial. What steps are going to be taken to resolve this case?